fraught context in which we hold today's hearing on the constitutional framework for Congress's ability to uphold standards for member conduct. Events over the last few months have put members of Congress on edge, and the emotional repercussions of these events continue to ripple through the House of Representatives. To be absolutely clear, my hope in holding this hearing is not to increase the tension inside the People's House, an institution that we all proudly serve in. Rather, I hope this hearing will serve as a productive exercise in educating ourselves and the public about the scope of Congress's authority to maintain discipline within its own ranks as informed by relevant precedents and policy considerations. Let me clear what this hearing is not about. We are not here to adjudicate allegations about potential wrongdoing against specific colleagues, nor are we here to speculate about what punishments could be meted out against any of our colleagues. Nor are we here to pass judgment on who does or does not meet minimum qualifications for office, which is also, constitutionally speaking, not a question of member discipline. These questions are outside of the jurisdiction of the subcommittee. Article 1, Section 5, Clause 2 of the Constitution provides that each House of Congress may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. Beyond this short provision, the Constitution contains few textual limitations on the substance of each House's authority to punish members for misconduct or to protect the institutional legitimacy and dignity of the House. In theory, other parts of the Constitution, like, for example, the Equal Protection Clause, may act as an additional limitation on Congress's exercise of authority to discipline members, though that proposition has not been tested and is rather theoretical. Beyond that limitation, the Constitution seems to leave the meaning of, quote, disorderly behavior, unquote, to each of the houses to define themselves. In light of the Constitution's limited textual guidance, we must turn to constitutional history, relevant precedents, and any lessons we may be able to draw from this information to guide any future decisions about members' discipline. Luckily for us, we have an outstanding panel of experts to help outline and elucidate this information for us. I will use this opportunity to note two things about precedent. With respect to expulsions of House members, there are only 5 instances when the House has expelled members. 3 of those instances occur.
Now, I can no longer hear the chairman at this point. I can see him, but I can't hear him.
This is Garcia. I can't hear the chairman either. Mr. Chairman, we cannot hear you, sir.
I cannot hear him either.
Oh, and he's still talking away. They're going to make a motion to adjourn.
Does anybody understand? Sounds like doesn't work. Hello.
We suddenly have you back
sound
now.
on Max. I've got sound on.
We can hear you now. We can see you now, but we couldn't for the last
I can't hear you. You're going in and out. Well, can you hear me now? You can hear me now. Okay.
Yeah, I can hear you now, but I can't see.
Well, I'm great.
We can hear you, but we can't see you.
This is Garcia. I can neither hear or see you, but I don't know you're talking.
The Senate has expelled 15 members, with 14 of those expulsions occurring during the Civil War. Again, because members either represented seceding states or otherwise supported the Confederacy. Can you hear that?
Yes, but
we
still can't
cannot see you.
Well, I've got a blue tie and a blue coat. I would also note.
Are you smiling?
I would also note that both the House and Senate took action shy of expulsion against other members stemming from their Civil War. I'm going to yield right now. I'm almost finished. I'd like to make note about exclusions. That's a different situation.
Well, now, Mr. Chairman, the chairman of the full committee has requested that you suspend while they work on the problem.
Sure. It's been suggested that I recognize Mr. Johnson for an opening statement. Can people see Mr. Johnson?
Yes.
Can people hear Mr. Johnson? Mr. Johnson, the honorable gentleman, Freeport, Louisiana.
Thank you, Mr. Chairman. I'll try. I hope the audio and the video will work. Somebody stop me if it doesn't. Look, I'm just going to be honest. We want to approach this hearing in good faith, and I hope that our suspicions about it are wrong. I really do. I mean, I appreciate what you said in the opening that we could hear, that you don't want to, increase the tension around here. But, some of the things that have happened, just very, very honestly, in the last day or two, have not met that standard. A letter today was issued by the 3 Republican members of the House Committee on Administration to Chairperson Lofgren. That's Ranking Member Davis and Representatives Loudermilk and Stile. And I wanted to read you just an excerpt from that letter. It's addressed to Chairperson Lofgren, dated today. It begins, "It has been over 2 months since the U.S. Capitol was attacked. Our committee has held no hearings and there are none scheduled. And this is unacceptable," they write in the letter. "Given our committee..."
Mr.
Yes.
Johnson, I'm
Yes.
sorry, sir, but there's a lot of static. I cannot hear you clearly.
Is it static on my line, or is that someone else's line?
I'm not techie enough to know. I just hear a lot of static, and it may only be me. I'm just having a hard time hearing you.
Let me soldier on and we'll see if it gets any better. I think it may be all of our bandwidth here on the Hill today. I don't know what's going on, but I was reading this excerpt from the letter that the Republicans sent to Chairperson Lofgren today, and they say that the committee's held no hearings yet. They're none scheduled, and it's unacceptable. They say, given our committee's primary jurisdiction over the entities responsible for preparing the Capitol for January 6th and maintaining it after, we should be the ones leading on a review and not other committees, and not your personal office, they say to Chairperson Lofgren. But while the committee has taken no action since January 6th, your personal office has managed to review the social media of 147 Republicans and then released a nearly 2,000-page report insinuating that our colleagues who we serve and work with every day were somehow complicit in an attack against our Capitol. These are the same colleagues we were with on the House floor on January 6th as rioters entered the Capitol and tried to break through the doors of the House chamber. They continue, "This report and its conclusions are not only wrong, they're offensive to your colleagues. It's also a questionable use of your members' representational allowance. As the chairperson of the committee, which is responsible for overseeing the rules governing the use of the MRA, you more than anyone else should know that the handbook is clear when it states, quote, the MRA may only be used for official and representational expenses, unquote. Using your personal office resources to investigate other members cannot be considered to be related to your representational duties to your district." They continue, "This report also contains concerning language and content that is inconsistent with the Communication Standards Commission regulations regarding the rules on decorum and civility. Additionally, there's a longstanding prohibition on official websites directly linking or referring to websites created or operated by a campaign or any campaign-related entity. Your report, posted on your official personal office website, directly links to the campaign accounts of 75 candidates." It goes on, but what Ranking Member Davis and Congressman Loudermilk and Stile were saying is that this is a Rubicon that's being crossed here. It's an unprecedented event that we're seeing. And I just want to say that many of us regard this as a new low for the United States Congress. And I say that with great regret. Look, our Democrat colleagues seem to us to have chosen to weaponize everything here now, and now we're going to do it with the House rules. How can we draw any other conclusion based on this? First, HR 1 is rammed through the Congress, and that forces hardworking American taxpayers to fund political campaigns with their treasure. And now we're going to use precious taxpayer dollars to fund political opposition research on our own colleagues in the House. This is not a place we need to be going. It's a brazen, we think, outrageous abuse of power, and it is contributing to the destruction of this institution. Look, Representative Lofgren's report is an attempt to criminalize politics and silence members who dare to speak. And they're doing this, she's doing this, I guess the party's doing this by some decision, by the attempted use of fear and intimidation and misinformation. That can't work. We can't allow that. That's not who we are as Americans. Representative Lofgren and other Democrats refuse to acknowledge that they engage, by the way, in the same exact behavior that they accuse Republicans of using to, quote, threaten our democracy, unquote. Remember, the Democrats have objected to the counting of electoral votes after every presidential election won by a Republican this century. I'm going to close with this. And I hope, as I said at the outset, that we're wrong about this, where all this is leading. But we shouldn't need a hearing today. We shouldn't need a reminder to acknowledge that for more than 225 years, the House and the Senate have used the authority of Article 1 of the Constitution to police conduct of our respective members. For over 50 years, the House has had a standing committee charged with exercising this authority. The Ethics Committee and the House rules are in place to ensure, of course, that we all conduct ourselves according to the maxim that, quote, public office is a public trust, as it says in our manual that we all have a copy of. We all agree the House ought to enforce those rules fairly and vigorously, but we also have to agree that it should never be done in a vindictive manner. And most of all, these rules never should be used for political purposes or try to censor or silence the other side. That's what this looks like today. Using the House rules in this manner demeans the Congress as an institution. And it amounts not only to silencing the targeted member, of course, but also the constituents that that member represents in our representative form of government in a constitutional republic with our democratic principles. I hope we're wrong about this committee hearing, about where this dangerous new Democrat strategy is leading. If not, I'm going to say we're all in real trouble, and I'll yield back.
Is Mr. Cohen on the line?
Yes, can you hear me?
Yes.
Good. Well, I couldn't hear Johnson real well. I presume he just said he understood what I said and we're all here in a kumbaya mood. Is that correct?
Something like that.
I heard something. Mr. Ness, Chairman of the full committee, is recognized for 5 minutes.
Thank you, Mr. Chairman. Today's hearing on the nature and scope of Congress' authority to discipline its membership is an important one. It is also not the first time the Judiciary Committee has examined Congress' authority in this area. At least as far back as 1914, when the committee produced a report on this matter in relation to a select committee investigation into an alleged bribery scheme, the committee has served to inform members and the public about the constitutional underpinnings of the House's disciplinary authority over its membership. Just like today, members then considered the scope of Congress' disciplinary authority, and without a doubt, our witnesses will note that this has been a perennial institutional debate since our nation's founding. One broad principle members and witnesses likely agree on, though, is that Congress' authority to discipline its membership is very broad. Under Article 1, Section 5, Clause 2, each House of Congress can discipline any of its members for, quote, disorderly behavior, unquote, a term that the Constitution leaves undefined. Indeed, the only explicit textual limitation on this power is a procedural requirement that any expulsion of a sitting member requires a 2/3 vote of the chamber. Under that same provision, each House has the power to make rules governing its own proceedings, and thus each has the authority to devise disciplinary measures short of expulsion, such as censure or the levying of fines. Another likely area of agreement is that this broad authority is not understood solely as the mere power to punish individuals for misconduct. It is also a basis for protecting and ensuring the dignity, integrity, and legitimacy of congressional proceedings. Simply put, the Constitution provides each House of Congress the authority to hold members accountable for misconduct so that each has the means to protect the public's faith and esteem in this institution. This authority is the basis for each House to ensure the continued functioning of its proceedings, particularly under the gravest national circumstances. There have only been 5 expulsions in the history of the House of Representatives, with 3 of them occurring in 1861 at the onset of the Civil War. Given how central this authority is to the operation of Congress as a coordinate branch, the Supreme Court, with only a few notable exceptions, has largely left it to Congress to determine the constitutional limits of its authority to discipline its membership. Thus, like other constitutional matters vested solely within Congress' purview, past precedent and historical practice have played a large role in shaping each chamber's understanding of the limits of its authority, informed each chamber's exercise of that authority, and contributed to the evolution of modern disciplinary practices. Today's hearing is an opportunity for members to hear from and ask questions of a panel of excellent witnesses who can educate us on the constitutional origins and limitations on Congress' authority to discipline members and what general policy principles may have evolved regarding the House of Representatives' exercise of that authority over the past 2 centuries. Distinct from these questions regarding constitutional authority and policy is the question of how the House should exercise its power in individual cases, theoretical or otherwise. But that is not the subject of today's hearing. As Chairman Cohen explained, we are here today to discuss and understand the constitutional principles and historical precedents that inform the House's disciplinary authority and policies. We are not here to apply them to any individual or circumstance. I thank the witnesses for appearing today, and I look forward to their testimony. I yield back the balance of my time.
Can you, Mr. Chairman, I couldn't hear you. I don't know if you're recognizing me or not.
Mr. Chairman, I cannot hear you. This is Garcia.
I'll recognize, if the chairman, if Mr. Cohen can't hear people, I will recognize Mr. Jordan for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, we had a short 1-minute video we wanted to share, but it looks like that we're not able to do that. Is there a reason?
I'm not aware of any reason.
It's not letting us hit the share. That's not open for us to use. Does Mr. Cohen know? Our staff just told me that Mr. Cohen's staff has not given us access to share the video. Is that accurate?
So you have to check.
We'll have to check on that.
Okay.
Okay, we're up on the phone. Turn my iPad off.
That was so loud.
Yep.
Control now or Georgie? I've got. Can anybody hear me?
I can hear you.
Good. Yeah. Well, I switched machines. I'm on a new machine, so I guess we're back, and I think we're okay.
But we're still not okay because we wanted to share a video.
I'd love to see a video. I love videos. Right. I don't know anything about any permission being asked or not asked or anything else.
We're not able to show it, Mr. Chairman. I mean, we'd like to.
What is the video? Give me an idea.
A video of people objecting on January 6, 2017, to the counting of the electors when President Trump won on January 6, 2017.
Well, I have no idea. I don't know anything about that, but the fact is that's not really particularly, and I don't mean to be argumentative or anything, Mr. Jordan, but that's not relevant. We're not going into anything that happened with any of that stuff.
Not relevant? The
Yeah,
chairman of the House Administration Committee just released a 2,000-page report Going
That's
after
not part of this
140,
hearing.
140, oh, not part of this hearing? You got to be kidding me. 140 some Republicans?
That's the House Administration Committee, not us.
That's not part of,
Well-
not part of this hearing, and I don't really know.
Well, she's a member of the Judiciary Committee. Maybe you guys-
She's not a member of this subcommittee, and as you well know,
She's a member of the Judiciary Committee.
so what? That doesn't mean she's not a member of the subcommittee.
Well, Ranking Member Johnson just read a letter talking about this very issue. This is entirely relevant. That report comes out a few days ago, and you have this hearing this week. Just coincidence?
The report was
Let me
issued to us this afternoon.
let me suggest, if some technical difficulty is preventing that video, why don't you just describe the video so we understand it, and let's proceed.
I'll read my statement. President Biden campaigned on a promise of unity, but Democrats in the House, like Chairman Lofgren, are putting together reports that attack Republicans, over 140 Republicans.
Mr. Jordan?
Let's
We
be
can't-
clear. Chairman Lofgren's report is a
Mr. Jordan,
2,000-page.
we can't see you now.
I
Is
can't,
the camera gone out?
I can see him fine.
I can't see him, and I can't see anybody other than myself now. I see Mr. Jordan has just popped back on.
I mean, this has just
See
been,
me?
it took us 30 minutes to get on to it was such a mess. I mean, this is a comedy of errors, this whole hearing. Democrats in the House, like Chairman Lofgren, are putting together reports that attack Republicans. Chairman Lofgren's report is a 2,000-page political opposition dossier put together at taxpayer expense. Think about that. Taxpayer dollars used to target fellow members of the United States Congress. Chairman Cohen went on television and accused without evidence Congressman Boebert of helping criminals storm the Capitol without a bit of evidence. Other Democrats have filed frivolous resolutions to censor or expel Republican members.
Mr. Jordan, would you yield for a minute?
So much for unity. Be happy to yield to the chairman.
Thank you. This has never been made clear. All I said on television is I saw Miss Boebert going with a group of people in the tunnel. I then said I didn't see anybody involved in the insurrection, and I also said this very well may have just been the historical record of her getting sworn in for the first time, and people wanted to go see it.
Come on. You said
Go to CNN, Jim. Go to CNN, and you'll see that.
How about I read your
That's
how
what
about
I said.
how about I read your quote? She's not on the home team. She was with the visitors. How about that quote?
That she's not on the home team. She's when you tweet 1776, you're not on the home team. But that doesn't have anything to do with her leading the insurrectionists. I said she specifically could have just been going up there for a celebration.
You know what?
And
You know
that
what?
was not
You know what?
mentioned.
You know what you did, Mr. Chairman. Other
Yeah, no,
Democrats
I
have
did.
filed
That's what I
frivolous
did.
resolutions to censor or expel
Go on.
Republican members.
Go on with your calendar.
So much for unity. Was it my time, or are you just going to run the whole thing? Is it my time?
It's your time to you continue with your calumny.
Excuse me, I didn't hear what you said. Continue with what?
Your calumny.
Oh, well, I'll continue with presenting the truth. These same Democrats spent 4 years accusing President Trump of colluding with Russia, allegations we knew at the time were false, and now the whole country knows are completely false. 19 minutes, Mr. Chairman, 19 minutes into President Trump's term, the Washington Post read a headline, quote, "The campaign to impeach President Trump has begun." President Trump wasn't even done with his inaugural address, and you guys were working with the media to impeach him. And of course, the video I wanted to play talks about what happened on January 6th. But I'll tell you what I'll do. I'll just read from it. I'll read from the Congressional Record. Congressional Record, House of Representatives, Washington, Friday, January 6, 2017. Mr. McGovern, Mr. President, I object to the certificate from the state of Alabama. Mr. Raskin, state of Florida, he objected to. Ms. Jayapal, Mr. President, I object to the certificate from the state of Georgia. Ms. Lee, Mr. President, I object to the state of Michigan. Mississippi, Ms. Jackson Lee, Mr. President, I object. Mr. Grijalva, Mr. President, I object to the certificate from the state of North Carolina. Ms. Jackson Lee, Mr. President, I object to the state of North Carolina. Ms. Jackson Lee, I object to the votes from South Carolina. Ms. Jackson Lee, Mr. President, I object to the votes from Wisconsin. Ms. Maxine Waters, the state of Wyoming, Is there one United States senator who will join me in this letter of objection? So Democrats, think about this. January 6, 2017, the chairman of the Rules Committee can object to Alabama, a state President Trump won by 30 points.
Hello?
Yes, sir. You need me?
Yeah, you should probably mute though, Mr. Chairman, so I can, while I'm talking. Again, one more comedy of errors in this committee hearing. Mr. Maskell, the lead impeachment manager, can object to Florida in 2017, and Maxine Waters, chairwoman of the House Financial Services Committee, can object to Wyoming, a state that President Trump won by 40 points. But somehow Republicans, Mr. Chairman, aren't allowed to object to Pennsylvania, where they changed the law unconstitutionally in 3 different ways. Pennsylvania law says the election ends at 8 o'clock on Tuesday. The partisan Supreme Court went around the legislature, said, no, it's going to end on Friday. State election law says, for mail-in ballots, there has to be signature verification. Secretary of State, partisan Secretary of State said, nope, we're not going to do that. And for 2.6 million ballots, they didn't follow the law because some elected Democrat, not the legislature, decided that. I can't object to Pennsylvania, but Democrats are allowed to, on January 6, 2017, object to Wyoming and Alabama. I mean, you've got to be kidding me. For 4 years, there was no let up in trying to overturn the 2016 election. In fact, here's what Hillary Clinton said last fall, fall of 2020. She said last fall, the election was stolen, and she called President Trump illegitimate 4 years after he was elected. But somehow when Republicans object on January 6, 2021 to unconstitutional changes made in key swing states, somehow that warrants a 2,000-page political dossier by the chairwoman of the House Administration Committee. And now you're going to have a hearing on this subject? Maybe we'd be better served, Mr. Chairman, if the full Judiciary Committee would have a hearing, just any hearing. Why don't we have a hearing on the border crisis? I mean, we all know there's a crisis down there. For goodness sakes, you're putting migrant kids in NASA facilities. Can't have a hearing on that. Can't have a hearing on cancel culture. The attack on the First Amendment. This is the Judiciary Committee. The committee is supposed to be in charge of protecting the Bill of Rights, the Constitution, and free speech rights. Can't have a hearing on cancel culture, but we're going to have a hearing in this subcommittee on a report by the chairwoman of the House Administration Committee that targets Republicans. It is wrong. It's time the Judiciary Committee did its job and focused on the issues that matter to the American people, like the border crisis and like the cancel culture attack on the First Amendment. With that, I would yield back.
We welcome our witnesses and thank them for participating in today's hearing. I will now recognize each of the witnesses, and after each introduction, we'll recognize that witness for his or her oral testimony. Your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony to 5 minutes. In the absence of a timing light, I will note orally when 5 minutes have elapsed and bang my gavel, and there will be also a timer on your screen, so please be mindful of it. Before proceeding with testimony, I'd like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to this subcommittee, and any false statement you may make today may subject you to prosecution under Section 1001 of Title 18 of the United States Code. Our first witness is Mr. Jack Maskell. Mr. Maskell or Maskell, and you'll please correct me when you start, worked as a legislative attorney in the American Law Division of the Congressional Research Service for more than 40 years, where he provided nonpartisan legal advice, analysis, and assistance to members of Congress, congressional committees, and staff on legislation and legislative matters, such as governmental ethics laws and regulations, conflict of interest laws, and congressional discipline of members. He is the author of the original House Ethics Manual in 1976. He received his JD from American University, Washington College of Law, and a Bachelor of Business Administration and Economics from the UMass Amherst. Mr. Maskell, you are recognized for 5 minutes, sir.
Thank you, Mr. Chairman. Mr. Chairman, Madam Vice Chair, and members of the subcommittee, thank you for the invitation to address you on the subject today. You know, when analyzing congressional authority to take certain actions, some of the more difficult questions may involve concepts of implied authority from the Constitution or even inherent authority of legislative institutions generally. But that's not the case here. Concerning member conduct, there is a direct and express authority in the Constitution for each House to address and, if need be, to discipline their members regarding their conduct. In imposing conduct standards and discipline, the House operates through its rulemaking powers, and these powers are set out together in the same clause of the Constitution. The authority was adapted from British parliamentary practice, as well as the experience of the colonial legislatures. Legislative and constitutional scholars have emphasized that the underlying justification for this power is to protect the integrity and dignity of the legislature and its proceedings, and not merely to punish an individual. As noted in Deschler's precedents, internal disciplinary action is, quote, rooted in the judgment of the House as to what was necessary or appropriate for it to do to assure the integrity of its legislative performance and its institutional acceptability to the people at large as a serious and responsible instrument of government. For these reasons, the authority of the House to discipline its own members has been applied and interpreted broadly to a wide range of conduct wherever it may occur, which the institution of the House believes is warranted. And that is, in the end, the actual standard for House discipline, that the House may discipline those who it believes have breached its privileges or decorum or have damaged its integrity or reputation. In practice, the House has employed several disciplines or punishments, including expulsion, censure, reprimand, and fine. I'll briefly talk about expulsion and censure. An expulsion, of course, involves the removal of a seated member by a 2/3 majority of those present and voting. At the outset, an expulsion needs to be distinguished from an exclusion. An exclusion, as was made clear by the Supreme Court in Powell versus McCormick, is not a disciplinary exercise. Rather, an exclusion by a mere majority vote involves a different constitutional authority for each House to, quote, judge the elections, returns, and qualifications of its own members. Generally, a member-elect may be excluded or prevented from taking the oath of office and his or her seat if the House finds that the member-elect was either not duly elected or has failed to meet the qualifications expressly designated in the Constitution. Now, although I've been talking about the power to expel or discipline, the House has recognized that there are other considerations in the policy or practice in doing so. Constitutional and legislative experts have agreed that while it is necessary to expel for gross misconduct that has disgraced the House, that unjustly or inappropriately expelling a member who has been duly elected by his or her constituents would be subversive of the rights of the people and at odds with the foundational principles of representational democracy. So the power to expel has been exercised cautiously in a circumscribed manner and has been reserved for the most serious offenses in misconduct. As the chairman said, in fact, only 5 members of the House have ever been expelled, 3 for disloyalty to the Union during the time of the Civil War, and 2 more recently for violations of criminal laws relating to the abuse of one's congressional position and power. Now, that number may seem very small, but it should be noted that a number of members who were facing probable expulsion had the good graces to resign from the House rather than put the House and themselves through that ordeal. As to censure, censure is a formal vote by a majority of members present and voting on a resolution disapproving a member's conduct, generally with the additional requirement that the member stand in the well of the House chamber to receive a verbal rebuke and reading of the censure resolution by the Speaker. There have been 23 censures of members, 22 members and 1 delegate actually, for conduct ranging from unparliamentary, insulting language on the floor to financial misconduct. Concerning the general grounds for censure, a select committee in the House in 1967 explained, censure of a member has been deemed appropriate in cases of a breach of the privileges of the House. There are 2 classes of privilege, the one affecting the rights of the House collectively, its safety, dignity, and the integrity of its proceedings, and the other affecting the rights, reputation, and conduct of members individually. Thank you very much.
Thank you, sir. And can you tell me how you pronounce your last name?
It's Maskell.
Maskell. Thank you. Thank you. Sorry I butchered it.
No problem.
Our next witness is Josh Chaffetz. Mr. Chaffetz is a professor of law at Georgetown University Law Center. His research focuses on structural constitutional law, American and British constitutional history, legislation and legislative procedure, American political development, and the intersection of law and politics. His second book, Congress's Constitution, Legislative Authority and the Separation of Powers, contained a chapter about Congress's internal disciplinary powers. Prior to joining the faculty at Georgetown, He served on the faculty at Cornell Law for 12 years. He earned his JD and his BA from Yale University. He also holds a doctorate in politics from Oxford University, where he was a Rhodes Scholar. He served as a law clerk to the Honorable Guido Calabrese of the United States Court of Appeals for the Second Circuit. Professor Chaffetz, you are now recognized for 5 minutes.
Thank you very much, Chairman Cohen, Ranking Member Johnson, and distinguished members of the subcommittee. Thank you for the opportunity to testify today regarding the constitutional bases, history, and scope of the congressional chamber's power to discipline their own members. This power is an important one, not simply because it facilitates the chamber's ability to do their business on a day-to-day basis, but more fundamentally because it allows them to fulfill their central role in our constitutional order. Now, as with so many of the powers and privileges of Congress, the power to discipline members has its origins in English parliamentary practice. Importantly, the House of Commons began exercising this power at precisely the moment it was coming into its own as an institution that could check and counterbalance the crown. Beginning in the middle of the 16th century, the House started to insist that it, and not royal officials or royal courts, was the proper body to police the conduct of its members. And as conflict with the crown heated up during the Stuart reigns, the power was used vigilantly to protect the authority of the House of Commons. Members whose conduct subverted parliamentary power in the service of royal power found themselves expelled on multiple occasions. And in 1716, members were expelled for aiding the previous year's Jacobite rebellion, an insurrection that sought to restore the Stuarts to the throne and undermine parliamentary gains made in the Glorious Revolution and its aftermath. But the power was also capable of being used in ways that harmed the institution and its claims to public legitimacy, as the 1763 proceedings surrounding John Wilkes demonstrated. Wilkes was expelled from Parliament for a publication criticizing the government of the day, and even after winning 4 successive elections, the House continued to refuse to seat him until 1774. 18th century American colonists were deeply familiar both with the history of 17th century parliamentary opposition to the Stuart crown and with the more recent Wilkes saga. They took from these events the lessons that legislative discipline was important, but also that it could be dangerously abused to undermine the representative character of the legislature, a concern that was heightened if members were expelled multiple times for the same offense or expelled for conduct that was known to their constituents before they were elected. After relatively limited debate, the Constitutional Convention chose to give each chamber the power to discipline its own members, but in order to forestall what James Madison described as the potential for dangerous abuse during emergencies of faction, expulsion would require a 2/3 vote. The convention considered, but chose not to include, a prohibition on re-expulsion for the same conduct. Early practice under the Constitution makes clear that while the 2/3 bar was indeed effective at preventing factional expulsions, it also allowed minority factions to prevent discipline that was perhaps warranted. The vast bulk of congressional expulsions in American history are, as others have noted, associated with the Civil War, both members from seceding states and members from Union states who aided the Confederacy. Because of the difficulty of expulsion, starting in the early 19th century, both houses began making use of censure, which could be done by bare majority. 19th century political culture often saw members who had been censured resign and then seek re-election as a way of demonstrating that their conduct had the support of their constituents. Mindful of the lessons of Wilkes, those members were regularly reseated. It wasn't until the 20th century that criminal prosecution became a central mechanism of regulating member conduct. And the beginnings of criminal prosecution of members came with not implausible claims that the members were being persecuted for their opposition to parts of President Teddy Roosevelt's agenda. Nevertheless, across the 20th century, criminal law became increasingly prominent as a means of enforcing congressional ethics and congressional discipline, with cameral discipline largely coming in either after criminal proceedings had wrapped up or for matters deemed too minor to rise to the level of criminality. The one prominent 20th century exception to this was the 1954 Senate censure of Joseph McCarthy, an incident that was widely perceived as redounding to the credit and benefit of the Senate as an institution. So let me close with just a couple of big picture takeaways from this history. First, the power to discipline members is both broad and substantively relatively unencumbered. It's for the chambers themselves to develop their law on what constitutes disorderly behavior, and they should, in my view, do so with an eye towards both maintaining and strengthening the constitutional order writ large and Congress's central role in it. The primary constraints on the power are not substantive, but procedural. Expulsion, which poses the greatest potential threat to democratic governance, requires a 2/3 supermajority. And all forms of discipline are subject to a Wilkes-derived principle that conduct known to the constituents prior to election should generally not be punished. That said, the framers chose not to encode this as a rule in constitutional text, and it's better understood as a strong but not dispositive argument. Second, and following on from the first point, the cameral disciplinary power is a means of promoting the House's institutional power. To the extent that primary responsibility for regulating members' conduct is outsourced to the executive and the judiciary, then those institutions not only have a tool with which to influence members, they also have a powerful argument for public support and public trust as against Congress. If other institutions are regularly seen to clean up Congress's messes, then the public will receive the lesson that Congress is corrupt, while those other institutions are paragons of rectitude. Congress would do better, in my view, to show the public that it can keep its own houses in order. Thank you.
Thank you, sir, Mr. Chaffetz. And now we'll have James Wallner. Mr. Wallner is a resident senior fellow at governance at the R Street Institute. He researches and writes about Congress, the separation of powers, legislative procedure, and the federal policy process. He also serves as professor lecturer at the Department of Government at AU, American University, and a fellow at the AU Center of Congressional and Presidential Studies. He received his master and doctor degrees in politics from Catholic University of America and his bachelor in political science from Georgia, University thereof. He holds a master's degree in international and European politics from the University of Edinburgh, Scotland. Mr. Wallner, you are recognized for 5 minutes.
Chairman Cohen, Ranking Member Johnson, members of the subcommittee, thank you for the opportunity to testify about Congress's power under the Constitution to discipline its members. It is an honor to appear before you today, and I look forward to your questions. It is important to acknowledge at the outset of my remarks that the committee is considering the extent of Congress's power to discipline its members just weeks after a violent mob attacked and ransacked the Capitol. Like most Americans, I was shocked, appalled, and saddened by that tragic event. We cannot go back in time, regrettably, to change what happened that day, but we are able to learn from it. And I believe that the most important lesson that that event can teach us is that it is better to resolve our disagreements via debate, deliberation, and compromise, instead of through force, violence, and intimidation. I believe that this context matters given recent calls for Congress to discipline members who objected to Arizona's and Pennsylvania's electoral results when the House and Senate gathered in joint session on the day of the attack to count the votes for president and vice president. Proponents of taking disciplinary action against those members appear to believe that they aided and abetted the Capitol attack by using procedures authorized by the House and Senate. Specifically, the members used procedures authorized by the Electoral Count Act of 1887 to adjudicate their concerns about two states' electoral results in the 2020 presidential election. Of course, Congress has the power to discipline its members, both today and in the past, for using the procedures authorized by law. The question, however, is whether it should use that power in specific instances. In whatever one's views are on the details of this specific case, I believe more generally that disciplining members for using authorized procedures to participate in the legislative process on behalf of their constituents undermines that process and makes it harder for Congress's members to debate, to deliberate, and to compromise as envisioned in the Constitution. Disciplining members for using authorized rules to adjudicate their concerns on the House and Senate floors reinforces the status quo, and it makes it harder for those opposed to it. People like the civil rights activists of the 1950s and 1960s, members of the women's suffrage movement, and abolitionists to change public policy inside Congress. Of course, the Constitution empowers Congress to discipline its members. My fellow witnesses have discussed that in great detail. And the Rules and Expulsions Clause empowers the House and Senate to expel members. But significantly, the clause does not define the appropriate grounds for expulsion. It instead raises the number of votes required to expel a member to a 2/3 majority. Delegates to the 1787 Federal Convention that crafted the Constitution set this higher threshold to expel members because they wanted to make it harder for majority factions in the House and Senate to use the power to silence their political opponents. For example, James Madison worried during the delegates' debate on this question that the expulsion power would be, quote, dangerously abused, end quote, by majority factions if the threshold was not set at a 2/3 majority. The Constitution empowers Congress to discipline its members to protect the integrity of the legislative process and to safeguard Congress's role as a crucible of legitimate political conflict. Congress has used this power to protect the space inside the House and Senate where Americans' elected representatives gather to participate in the activity of self-government on their behalf. Constitutional provisions like the privilege from arrest and speech and debate clauses suggest that the activity of members inside Congress is important. Self-government is what happens when Americans with different views come together in those institutional spaces to debate, to deliberate, and to compromise. Because Americans with different views participate in the act of self-government on the basis of equality, their political activity in places like the House and Senate inevitably generates disagreement or political conflict. That is why rules and legislative procedures are essential to making Congress work. They make it possible for members to compromise when they disagree with one another. Standards are important to protecting the integrity of the legislative process, but they facilitate debate, deliberation, and compromise only when they are adhered to voluntarily by all members. Such adherence requires that members know how those standards will be enforced in advance. Standards and rules are vital to what Congress does because its members can compensate for the difficulties inherent in self-government by preserving their ability to make and keep promises. When members cannot know with certainty the outcomes of their actions, the ability to make and keep promises in the forms of rules and norms, according to the political theorist Hannah Arendt, creates islands of predictability and goalposts of reliability in politics. In other words, rules make it possible for members to form expectations about how Congress will operate in the future. That, in turn, makes it easier for those members to settle for suboptimal outcomes to compromise in the present. Disciplining members for using the rules to achieve their goals undermines the ability of those rules to serve this role, and it makes enforcing the rules arbitrary. It also complicates members'
Wallner?
ability to... Yes, sir?
We've got a 5-minute rule and you're kind of gone. So if you wrap up real quick, I appreciate it.
Absolutely. Well, I would just say that Congress, I believe, should refrain from using its constitutional power to discipline its members for following the rules and should instead focus its effort on changing those rules moving forward. The ability of its members to debate, deliberate, and compromise ultimately depends upon it.
Thank you, sir. I appreciate your being a witness and I appreciate your testimony. Our final witness is Stan Brand. Mr. Brand is a partner in the Brand Woodard Law Firm, serves as Distinguished Fellow in Law and Government at Penn State University's Dickinson School of Law. From 1976 to 83, he served as General Counsel to the U.S. House of Representatives under the august Speaker Thomas P. Tip O'Neill, where he was the House Chief Legal Officer responsible for representing the House, its members, officers, and employees in connection with legal procedures and litigation arising from the conduct of their official activities. In private practice, he's represented numerous individuals and organizations investigated by or called to testify before Congress. Mr. Brand holds a JD from Georgetown University Law Center and a BA from Franklin and Marshall. You are recognized for 5 minutes, sir.
Thank you for inviting me to address this important topic, Mr. Chairman. It's nice to be back in the House, even just as a witness, even virtually. I'm a creature of the House of Representatives, having served as the first litigating House counsel under Speaker Tip O'Neill. It was during his tenure that I represented the House in defense of its constitutional authority at all levels of the federal judiciary, including before the Supreme Court. These cases, far-reaching and precedent-setting, involve challenges to the House chaplaincy, the legislative veto, subpoenas to the executive branch involving claims of presidential privilege, and the legislative immunity of members and officers of the House in civil and criminal cases, and the latter's intersection with the self-disciplinary power that is the subject of today's hearing. What I learned in the course of those representations was the dearth of judicial understanding of and appreciation for the House's unique and expansive authority to discipline its members. As I explain in more detail in my written statement, that is why I requested and the Speaker granted my request to enter the case of United States v. Helstosky in the Supreme Court. To disabuse the Supreme Court of its notion, as articulated in Brewster, that the process of disciplining a member is subject to the risks of abuse, is not bounded by procedural safeguards or standards, and is within the unbridled discretion of the House. Our amicus brief argued that the House's process, while not exactly equivalent to a judicial trial, was attended by the rudiments of due process and detailed rules of procedure, which seemed to at least earn tacit acknowledgement in its Helstosky decision a decade later. To sustain a robust self-disciplinary process free from judicial intervention, I believe the House must be sensitive to what the courts could construe as limits on its power. This does not mean the House should shrink from its obligation to police its members. As I explained in my written statement, to prevent what I believe has been overreaching by the Department of Justice in pursuit of its enforcement of criminal statutes, the House must have a credible enforcement process to allay judicial, indeed public concern, that members who violate its ethical rules will not be held accountable. The proper place to determine the applicability of House rules governing members' conduct is in the House. Although it is almost 40 years since I left the House, and I've been on the defense side of the table, as it were, in over 36 ethics proceedings in the House and Senate, I continue to advocate for the disciplinary power of the House. I filed an amicus brief in support of the certiorari petitions, for example, in Aaron J. Schock versus United States, seeking review of the Seventh Circuit rulings dismissing challenges to an indictment against former Congressman Schock based on the rulemaking clause and the speech or debate clause, which in my view pose serious threats to the independence of the Congress. I filed an amicus brief supporting certiorari in the criminal case of Richard Renzi versus United States because the indictment charged the performance of legislative acts. In that case, pre-legislative investigations and fact-finding, which I believe contravened the speech or debate clause. In both cases, I argued the proper forum for consideration of these alleged offenses was in the House, not before the judiciary. I pointed both to the Office of Congressional Ethics and the House Ethics Committee as the responsible offices for vindicating the House's self-disciplinary process for legislative misconduct. I continue to believe in that principle, and I welcome your questions in this matter. Thank you.
Thank you, Mr. Brand. We will now proceed under the 5-minute rule with questions, and I'll take the first 5 minutes here, it's prerogative. For Mr. Maskell or Mr. Chaffetz, much of the House's disciplinary practice is guided by precedent. What general principles or policies, if any, have evolved over time regarding the exercise of the House's disciplinary authority? Mr. Maskell, do you want to take it first?
Yeah, sure. Mr. Chairman, that's a good question. Stan Brand mentioned the fact that there's an entire rules that the House Ethics Committee has adopted that sets in motion procedures that would satisfy most arguments of due process. And so over the course of the number of years, although some courts and some people in Congress have thought that it could be a procedure just quickly on the floor without much due process. Respect for that process has come about over the years, and we now have these detailed procedures when, for example, an expulsion resolution is referred to the committee. We have all the due process questions and procedures.
Thank you, sir. Mr. Chaffetz, do you want to add anything to that?
I think he basically covered it. I would just add that sort of, from the earliest days of Congress, these questions have arisen whenever there have been, especially expulsion proceedings. There has always been a concern to have a sort of adequate procedure to protect the members. And you can understand why, right? These are members using discipline against their own colleagues. It's not surprising that they would have a sense that they want to be fair, if for no other reason than a sort of there but for the grace of God go I kind of feeling.
Thank you, sir. Mr. Brand or Mr. Maskell, what is the significance of the Supreme Court decision in Powell versus McCormick, I guess our Speaker McCormick, to Congress's power to discipline its membership? Did the case in any way alter the way Congress considers questions of member discipline? Mr. Brand, do you want to take a shot at that and explain Powell to us?
Yes, sir. Powell, of course, is an exclusion case, but in the course of interpreting the standing qualifications of office, age, citizenship, and residency, I think the court cast some doubt on the Congress's ability to exclude a member or to discipline, at least expel a member who had been reelected by his constituents in the interim. And that's a case where the Constitution in other sections provided a textual limit, at least in the court's view, on what the power of the Congress would be. As the other witnesses have pointed out, the expulsion clause by itself has no express textual limits, but the old saying in law school is hard cases make bad law, and the Supreme Court is always capable of taking jurisdiction over a matter where it thinks the Congress could have arguably exceeded its authority. So I think Powell is a warning light. It's not an express limitation, but the historical treatment of the power of the Congress to exclude in that case, I think, has to be looked at. And I would associate myself with Professor Chaffetz's written statement on the history of all of this, because it's incredibly important to understand how we got to the position we did in the Constitution. And he's outlined, the background in Parliament for all of this.
Thank you, sir. Professor Chaffetz, in the Constitutional Convention, which I'm sure you've read about, was congressional discipline discussed and how it should work? And were there any points of contention or concerns if there was any discussion?
So it was discussed, although it was discussed relatively briefly, right? So I mentioned in my written testimony that you get sort of this initial draft in the Committee of Detail that gives each House of Congress the authority to punish its own members for disorderly behavior, and says each House can expel, but not a second time for the same offense. Then the next draft we get with no explanation, they just drop the but not a second time for the same offense. And this is all before it comes to the sort of floor of the convention. And the floor of the convention, James Madison says, well, we have to worry about what he calls emergency of faction, situations in which he didn't want to use the word partisan, but factional differences would run so high that a majority faction might expel minority members. And so he says to guard against this, we should put in a 2/3 supermajority requirement for expulsion. The committee adopts that basically without much debate, and that's it. They're done with it. So overall, it was uncontroversial, and Madison made that sort of crucial intervention right at the end.
Thank you, Professor Chaffetz. My 5 minutes are up, and I now recognize Mr. Johnson for 5 minutes.
Thank you, Mr. Chairman. I wanted to ask Mr. Wallner, I appreciate all our witnesses. I appreciate your historical insights, and it is important to us. And I think that I just want to say at the outset here, I know I can speak for the Republicans on the committee. We recognize and appreciate this history, and we revere the House rules and the rules of decorum and civility and everything else that we're bound by here. The question is, though, I'd ask this to Mr. Wallner. Let me read an excerpt real quick from your written report to us and ask you about that. You said it on page 5, quote, when coupled with the rising toxicity of our current politics, members' tendency to disregard the rules when doing so helps them, to call for their strict enforcement when it does not, and to discipline their opponents for following the rules, exacerbates Congress's present dysfunction and makes it harder for the House and Senate to operate as envisioned by the Constitution, unquote. I certainly agree with that sentiment, but I wondered if you could unpack that for us a little bit more, Mr. Wallner, and tell us what harm might come by the House rules being used in a new way as kind of a political weapon.
Well, thank you for the question. The whole point of the House is to adjudicate disagreement between its members. And the rules are leverage that allow members to participate in that process. They are what allows members and gives them a voice to represent their constituents. And out of that struggle comes compromise. And I don't think we fully appreciate that. We don't understand that today, I believe, because we see Congress as a giant factory, and we think your job is to build widgets according to some blueprint that's been designed elsewhere. And when you have that view of Congress, all of a sudden, the rules are very concerning if they allow your opponents to win. We see politics as a means to an end, not a practice in which we participate. And so when you go down this road, it becomes very, very hard to get back. because you have adopted this view of politics as a production-oriented activity. And so therefore, I have no need to listen to you if I disagree with you, and I will ignore the rules if they give you a voice, but I will demand that those rules be enforced when they give me a voice. And I'm not a hypocrite for doing so, because we have two different outcomes. And I think that's exactly where we are. That's where our colleagues are, your colleagues are on the other side of Capitol Hill in the Senate right now with regard to the filibuster and the nuclear option, for instance. It's good one day and bad the other. And I think this really speaks to the problem of our politics. And today, if we can't adjudicate our disagreements in Congress, then where else are we supposed to do it? That's the problem that I think we need to grapple with.
No, I think you said that very well. And I speak to all the witnesses today and all of my colleagues on this committee. One thing that I think we can all agree with is that there has been, as you said, toxicity here on Capitol Hill. There's an increasing tension. I appreciate what Chairman Cohen said at the outset of this hearing. We don't want to increase the tension. We can't afford to do that because we have an escalation now. It's almost like the Cold War. It's mutually assured destruction by both sides. And we see that developing at a rapid pace. And many of us are deeply concerned about how we ever put this genie back in the bottle. And the only way to de-escalate it, I would say, with due respect to my chairman and my colleagues, is for us to not engage in this gotcha kind of politics. Just as you just said, the idea that a member in leadership would use their official office and MRA resources to review the correspondence of nearly 150 of her colleagues to produce a 2,000-page report where she effectively insinuates that those members are complicit in a crime is in no way a de-escalation. It is sparking a political war at the worst possible time. Both sides are guilty of this, right? There's enough of that to go around. But I guess the question is, maybe I'll start with you, Mr. Wallner, and any witnesses who want to weigh in on this. How do we possibly use the rules and act in an appropriate manner to de-escalate things around here? I'd love to hear your insights on that.
Well, the first thing I think is to be committed to the rules, even when they don't necessarily benefit you. And Congressman Jordan mentioned earlier the Democrats in the past who had objected to electoral counts during the counting of the votes for vice president and president. And sometimes members use rules to do things that you find unpleasant or that you find unhelpful. But the point is that you can argue against them. But if you weaponize those rules and you call into question their ability to use those rules, instead of saying maybe we should change the rules in general for everybody, then I think that's the general direction we need to head in. But if we instead say we're going to attack the rules instead, we're going to drag down those rules into the fray, and we're going to make it impossible for Congress to serve as that crucible of conflict that the framers designed it for.
Unfortunately, I'm out of time. I yield back. I appreciate all the witnesses for your time today.
Thank you, Mr. Johnson. Now recognize the chairman of the full committee, Mr. Nadler, for 5 minutes.
Thank you very much. I must say that unlike a lot of different hearings, I found all the witnesses entirely reasonable today. Let me ask, Professor, in your written testimony, you noted that the rulemaking clause and the expulsion clause's inclusion in the same section of the Constitution is likely not incidental. What's the relationship between these two powers, and how does the rulemaking clause inform the scope of the expulsion clause?
So the rulemaking clause is, in some sense, it seems modest from its text, but it's hugely influential. The rulemaking clause basically allows each chamber of Congress to give itself its own constitution, right? To create its own rules and structure its own deliberations. And then the punishment clauses basically come in and say, and if some of your members are going against those rules you've created or undermining the institution, then the chamber can do something about it, right? It doesn't have to be sort of stuck with members who are undermining the structure that it itself is empowered to create. So they go together hand in glove, and they are tremendously important for the power of the chambers.
Well, thank you. And Mr. Maskell, Congress' authority to discipline its members is generally understood to be quite broad. What constitutional constraints exist on Congress' ability to discipline its members?
Well, we're not really sure because the courts haven't really restrained it specifically or directly. In Powell versus McCormick, the majority opinion did note that Congress has questioned its power to expel after re-election after members is re-elected. However, in that same opinion, in a concurring opinion, Justice Douglas said, if this were an expulsion case, we wouldn't be here today. And that's because it's textually committed to Congress to deal with an expulsion. And so we haven't really seen it yet. Most of the restraints have been self-restraint, and the Congress and the House and the Senate itself questioning its policy to do so because they don't want to substitute its judgment for the judgment of the electorate. So if the electorate knew about conduct and still elected the member, the House and Senate have generally refrained from expulsion in those cases as a matter of policy.
Well, thank you. And Mr. Brand, first of all, let me say it's good to see you again. But let me ask you, can Congress impose discipline on a member separate from any judicially imposed criminal punishment for criminal conduct that occurred while in office?
Yes, in fact, in 1984, shortly after I left the House, former Congressman George V. Hansen was convicted of certain felonies regarding his financial disclosure. He was convicted, and the House Ethics Committee at that time had a rule that said any member who's convicted of an offense that carries a penalty of 2 or more years automatically gets that same conduct reviewed by the Standards Committee, albeit under a different standard of proof, not beyond a reasonable doubt, but preponderance of the evidence. And in fact, I was hired as outside counsel, and subsequently the House determined to reprimand Congressman Hansen for that conduct. So yeah, it's a parallel system, and it's independent from the criminal justice system. I point out, just for the memory of Congressman Hansen, that his conviction was reversed pursuant to a coram pro nobis petition after the Supreme Court overturned the decision under which he had been convicted. If I could, I'd just like to try to give Congressman Johnson some comfort, if I can, and point out that the House Ethics Committee, I believe, is the only committee in the House which is evenly divided between Democrats and Republicans. And in my 40 years of experience, that has acted, some people say critically, as a check on the committee acting in a partisan way. Because to get a proceeding concluded or to bring a proceeding, you have to have somebody from the opposite party agree to move forward.
Thank you. And let me just ask Mr. Markle, Mr. I'm sorry, 1 second. Let me ask Mr. Wallner, just comment on what the other witnesses have said and where you disagree with them, if you do.
I would just point out that the Supreme Court said in the 1892 case, United States v. Balin, that the power to determine Congress's own rules of procedures is unlimited to the extent that it doesn't violate other explicit constitutional provisions. So there are certain limits on that from the court's perspective. But I would also just point out that Congress, and I would encourage you and your colleagues not to adopt a Supreme Court-centric or legalistic view of this power. As James Madison said in 1834, as the legislative, executive, and judicial departments are coordinate and equally bound to support the Constitution, it follows that each must, in the exercise of its functions, be guided by the text of the Constitution according to its own interpretation of it. Congress does not work for the Supreme Court. Congress gets to interpret its powers under the Constitution as it sees fit as well. And so I would encourage you to think independently about that instead of looking to the courts and adopting an overly legalistic attitude towards what you are and are not allowed to do.
Thank you very much. I wasn't aware that Madison was still alive in 1834, but apparently, in any event, thank you very much. I yield back.
Thank you, Mr. Chair. I would now like to recognize Mr. Jordan for 5 minutes.
Thank you, Mr. Chairman. Mr. Wallner, are Democrats weaponizing the rules?
If Democrats are going to punish members for using rules, then it appears that they are weaponizing the rules, yes.
Well, so let me give you some examples. The Democrats have taken away the one amendment that the minority party has historically had in the House, the motion to recommit. So it's one last chance you get as the minority party to amend legislation that's passed, and they've taken that away from Republicans this Congress. Is that a weaponization of the rules?
So I would respectfully disagree whether or not that's a good idea. Departure, a very significant departure from the norm, and it clamps down on debate and deliberation in the House. But it is still setting rules and using its power under the Constitution to set those rules. And we can debate whether or not they're right or wrong. But by punishing members for following rules, that is a whole separate order of issues that I think should concern all members, Republican and Democrat alike.
Well, let's go with that question then. Is it appropriate to kick someone off of their committee assignments for things they said prior to coming to Congress when that person has been duly elected by the constituents in their district?
So this is a question that has been debated throughout Congress's history. I would point out that the House has the power to determine its committee assignments, but it does begin to start to look like a slippery slope when you start to penalize members for things that they did prior to their service, simply because you don't like what they did. You know, the question is, are you going to use your power on that committee to somehow undermine the Congress or disrupt the fabric of the Republic? Or is this simply a way to signal to one's constituents that you are strong on these issues by punishing some member whom is unrelated to you and your constituency?
How about bypassing the committee process? Do you think that's a good idea? It may be allowed by the rules. Do you think that's a good idea?
To the extent that the committees help Congress to develop, good, informative solutions to the problems we face, no, it does not appear to be a good idea.
I mean, the last 2 weeks, Democrats have radically changed election law. They've radically changed police law. Today, they voted on 2 pieces of legislation that radically changed gun law. None of those pieces of legislation went through the committee. Frankly, all of them were supposed to actually come through our committee, the Judiciary Committee, at least. Well, 2 of them or 3 of them all the way that we had sole jurisdiction. One committee we had one bill we had partial jurisdiction. None of them came through our committee. Next week they're going to pass 2 immigration bills that give amnesty to illegals, and those aren't going through committee either. You think that's healthy for the process and for this overall environment in Congress?
In the House, no, because the members of the House participate in committees. That's where you do your work, unlike the Senate, where most of it happens on the floor. And to the extent that the majority is bypassing committees specifically to avoid allowing members to participate in that process, that is something I think that is unhelpful overall to the health of our republic and the Constitution and the House under it.
Are you concerned about what I would call the ultimate rule change? This phenomena we now see in America called cancel culture. I would say we're talking about rules. That is like the ultimate rule change in the First Amendment. Are you concerned about what you're seeing? Well, let's do a specific example. We had 2 Democrat members of Congress write a letter to the carriers of certain television networks, asking them to consider pulling off Fox News, Newsmax, One American News from
politics. That's what makes us.
I would never, Mr. Wallner, I would never write a letter asking carriers to take down CNN and MSNBC because I disagree with most of what they say on those programs or those networks. I would never do that. My guess is you wouldn't either, would you?
No, sir.
No, I mean, because the First Amendment, but so I think this is a fundamental question for us to deal with. Do you have a functioning First Amendment when only one side's allowed to speak? And that seems to be, unfortunately, where the Democrats are heading. Do you have free speech when only the left decides what can be said? That is where we're headed. And as evidenced by that, again, we had 2 Democrat members of Congress specifically inquire. I should read from that letter, but they actually said they wanted to know, AT&T, how many people before the election, how many of your subscribers actually were watching Fox News, Newsmax, and One American News? Now, if that is not chilling, members of the government asking a carrier how many of the people who subscribe to your network were actually watching these 2 programs that they were encouraging to be taken off the platform. I think that's frightening, frankly. And the idea that we haven't discussed this or had a hearing on this, I think is even more concerning. Do you agree?
Yes, sir. And especially in the House, setting aside the First Amendment. Look, abolitionists, there were fights over the gag rule prior to the Civil War, saying you can't even bring up slavery. When you can't, as a member of the House, raise issues that your constituents and you feel are important, then I'm not sure what you're doing there. In the institution, I'm not sure what it's doing there either. The House isn't a factory. It's a place where people go to debate, to argue, to disagree, and to compromise.
Make your best argument, get your best hold, have the debate, shake hands when it's over. I thought that's what the First Amendment was all about. And I thought the House Judiciary Committee was supposed to be the committee that defended that right. Instead, we have far too many people encouraging the cancel
Your time is
culture.
up, Mr. Jordan.
Thank you, Mr. Chairman.
You're welcome, sir. Next, recognize Mr. Raskin for 5 minutes.
Mr. Chairman, thank you very much. I want to agree with Mr. Johnson about the toxicity of the present political culture in Congress. I thank him for his comments. I think that it almost indisputably began on January 6th with the first violent insurrection and mob attack against Congress in the history of the United States, incited by President Trump in an effort to overthrow the results of the 2020 presidential election. So I want to respond to today's waterfall of counterfeit outrage and indignation. I have to thank Mr. Jordan for pointing out the obvious, that members of both political parties have historically raised objections in the Electoral College certification process, but only one president with members of his party in tow has incited a violent mob to attack Congress during the actual execution of its Electoral College duties and the counting of the electors. So I wish he had been able to show his video, because it would have demonstrated people getting up, in my case, for perhaps 15 seconds, making a totally peaceful, nonviolent objection, not in any way inciting a violent mob to try to overthrow the peaceful transfer of power in America. And it's shameful that we even have to point this out, but equating the two is absurd. Mr. Jordan continually said that he doesn't have the right to object. They get to object, but he can't object, and so on. That's absurd. Has he been punished in any way for the objections that he made? Has there been a single Republican member of the House that has been punished, admonished, censured, reprimanded in any way for making an objection? Not at all. What we're talking about is a violent attack on the Congress of the United States, and one would have hoped in Madisonian fashion that all of us would have stood up for our institution rather than sticking in a cult-like fashion with our political party and a president who essentially incited a mob attack on us, on the lives of our people, and his own vice president as they chanted, "Traitor, traitor, traitor," and "Hang Mike Pence, hang Mike Pence." Mr. Jordan talks about cancel culture, which is fascinating to me. Of course, Donald Trump tried to cancel out the entire election and cancel out our lives in the process. 5 people were killed during the January 6th attacks as they sent mobs out to look for Vice President Pence, to look for Nancy Pelosi. Lindsey Graham said afterwards, they could have had a bomb. We all could have died. Doesn't anybody have any sense of democratic self-respect about our own institution? Perhaps cancel culture doesn't apply to our lives and our workplace and our government. All right, let's say it just applies to speech. Let me introduce you to someone named Liz Cheney, who happens to be the chair of the House Republican Conference, who had the courage and the patriotism to stand up and to say that Donald Trump had solicited the mob, he assembled the mob, he incited the mob, he lit the match that led to the attack on Congress. None of it would have happened without him. Now, you might agree with it, you might disagree with it, whatever, but what did they do? Well, Mr. Jordan and his friends tried to overthrow her. They tried to cancel out her leadership and to overturn her leadership in the House Republican Conference. Now, fortunately, that was too much cancel culture for the other members of the caucus, and they rejected that on a 2-to-1 vote. But they've gone ahead to try to get her political party in Louisiana to cancel her out by censuring her. They did the same thing to Senator Cassidy in Louisiana. They did the same thing to Senator Burr in North Carolina. All over the country, they're trying to censure them for doing their jobs and upholding their oath of office. You talk to me about cancel culture. You invented cancel culture. This right-wing cancel culture is run amok as they try to turn a political party, a once great political party, into a religious cult where everyone has to follow the cult of personality around Donald Trump. Here's what Donald Trump did. He canceled out Chris Krebs, the director of cybersecurity, for pushing back against lies that the election was stolen. He urged people to cancel HBO because Bill Maher was mean to him. What a snowflake. He urged people to cancel their subscription to New York Magazine because of a mean tweet that was sent out by an editor. He called for Charles Krauthammer to be fired because he was critical of Donald Trump. He said Megyn Kelly should be boycotted because she was too negative towards him. He called for the firing of every NFL player in the league who didn't stand for the national anthem because he didn't agree with their exercise of their First Amendment rights. And then he claimed the right to pull the broadcast licenses of NBC and CNN and so on. I haven't heard Mr. Jordan talk about any of that. You talk about cancel culture. You invented cancel culture, and you continue to stand by why they try to cancel out the voices of anybody in the Republican Party who disagrees with Donald Trump. I yield back.
Mr. Chairman.
Thank you, Professor Raskin. I appreciate your 5 minutes. And next recognizes Mr. Chairman.
Mr. Chairman, I have to ask that those words be taken down. The name calling of the former president obviously violates the rules. Ironically, on a day when we're talking about the importance of decorum and the rules, I love my friend Jamie Raskin, but he went over the line, and I think that those comments need to be stricken from the record.
Is that a motion?
That is a motion.
Mr. Chair, if I stated something false about the private citizen who asserts he's a private citizen, Mr. Trump, which is why he didn't come and testify in his impeachment trial in the Senate. If I stated something false, I will retract it. Mr. Johnson, did I misstate something about what he had done?
Well, I don't know. You called the former president a snowflake, and you implied lots of other nefarious things about your colleagues, but we'll let the rest of that fly. But
all right, okay, I will withdraw the snowflake comment and keep that to myself if you don't want to hear that today. I withdraw that.
I'm just saying that you just demonstrated exactly what it is that we're talking about here today, Jamie. We've got
Mr. Johnson, wait a second. I was responding to Mr. Jordan. I didn't hear you correct him on any of the things he said. He laid into us and accused us of cancel culture, and I turned it around. Reverse uno, as my nephew Bowman would say, okay? He accused us of cancel culture, and I'm saying that his caucus and his approach is all about cancel.
The chairman is going to interrupt here, and we're going to recognize Mr. McClintock, who is next in order. Mr. McClintock, you're recognized for 5 minutes. Is Mr. McClintock with us? If he's not, we'll move to Mr. Roy, and he's recognized for 5 minutes.
I thank the chairman.
You're welcome.
I have a few questions for Mr. Wallner. Mr. Wallner, would you agree with me, and I just keep your answers reasonably short so we can get through because I only have 5 minutes, but would you agree with me that the purpose and structure of the Constitution is set up for Congress to be able to represent our constituents, get together, vote, debate, amend, and that it should be a purpose where the body is reflecting people and that the rules that are put in place are made to make the body function better?
Yes.
And do you believe that the rules that we're talking about here, where we're talking about targeting members and going after members in either direction, by the way, is something that, generally speaking, is making the body function better?
No.
Are you aware that I've had a number of engagements on the floor in colloquy with the majority leader, Mr. Hoyer, about restoring regular order and have made statements along those lines about amending, debating? And is the gentleman also aware, or is the witness also aware, that we have not had an amendment offered in open rule for 5 years this coming May under both Republican and Democrat leadership?
I'm not aware of the specifics, but that doesn't surprise me.
Is it better to focus our energies on what's going on inside the body and commentary inside the body versus commentary on social media and outside the body when it comes to setting up our rules, in your opinion?
Well, inside and outside are permeable, and people who are opposed to the status quo and the establishment, if you will, have no choice but to go outside of the body to try to get more leverage and to try to then play an outside game and ultimately prevail inside the body. This is how we got civil rights reform. This is not a left or a right thing. I think the rules should be focused on how do you facilitate member participation in the process. That's the important thing. They need to be consistent, they need to be spelled out in advance, and they need to be adhered to voluntarily by everyone.
Do you think that what we're talking about here is the power, I think, what we're talking about, although it's been kind of all over the place, the power of Congress to set the rules for its own body? Nobody debates here. We can set our rules. But in terms of our constitutional framework, in my opinion, it's not about as much the power of Congress to do it than it is the wisdom to do it. In other words, if we're setting our rules to target each other's speech, to go after members for speech and debate and engagement outside or inside the body, is that not flying in the face of the very purpose of Congress? Forget about the power to do it. Is it wise to do it?
I don't believe so. And I believe that everyone in this hearing appears to agree that Congress can pretty much do whatever it wants in this area with regard to its rules, setting aside maybe one or two few limitations. The question is, as I said in my testimony, whether or not it makes sense for Congress to do so. And to answer that question, I would encourage you and your colleagues to take a step back and try to think more fully about what it is that Congress is supposed to do. And when you do that, I think you see the real dangers that are presented when Congress begins to weaponize the rules and use them to silence members inside the body.
Is the witnesses, you, Mr. Wallner, are you aware that I was a member who did not object to the seating of electors on January 6th?
I was.
And with all due respect to my colleague from Maryland, Mr. Raskin, who used the phrase counterfeit outrage, I also did not support impeachment. And I had a number of conversations with my friend from Maryland about why I did not support impeachment. And it was very much about the targeting of free speech and the targeting of language that was used in speeches and the danger, in my view, of going down that road. If you're saying something like, we should take the fight to the Capitol. Okay, and that somehow that means that that's a problem. I've said language like that all the time. Take the fight to your state legislatures on election reform, for example. Do you agree with me that it is dangerous for us, with respect to speech and debate and free speech, to target language that members of this body and or in the White House are using along those lines?
I believe it is very dangerous, and I believe that it is, some may say it's a slippery slope argument. I do not think that's the case. We can go all the way back to the first expulsion, the first impeachment, the time of the Alien and Sedition Acts. There is a long history in this country of factious majorities, to use Madison's language, to penalize and try to silence their political opponents by using the rules. And I think that's something that we have gotten away from in this country for good reason, and I think that we should continue to strive in that direction.
Mr. Chairman, I know my time's up. I would just indulge it for maybe 20 more seconds. I would just offer that as one who did not object, that I could say in response to my friend, Mr. Raskin from Maryland, I have heard and seen a number of my colleagues on the other side of the aisle approach me saying, will you work with us on bills because we're not going to work with those 140 members who objected. And I'm just saying to the body here, this is not good for the body. This is not good for us to engage that way. When my friend from Maryland, Mr. Raskin, objected in 2017, when Ms. Waters from California objected in 2005 and 2017 as well. In any event, my point only, Mr. Chairman, is I know you're saying this is about a bigger question beyond January 6th, but in truth, we know it's not, as this whole conversation is suggesting. And I would just suggest if we police each other's speech, we're getting away from our purpose. We never debate on the floor. We never offer amendments on the floor. Let's debate. Let's fight it out. A little bit like we're doing here, but let's do it on the floor. Let's engage on these issues. I appreciate the indulgence of the chairman.
You're welcome, Mr. Roy. And if we debated like you debated, I'll be hunky-dory. I recognize Mr. Henry Calvin Johnson.
Thank you, Mr. Chairman. And my dear colleagues, no reasonable person can, in good faith, compare what happened on January 6, 2017 with what happened on January 6, 2021, when the President of the United States of America, aided and abetted by members of Congress, incited an insurrection that resulted in an armed assault on the United States Congress that resulted in the deaths of 6 people, including 2 Capitol Hill police officers. On January 6, 2021, many of us here today personally experienced just how fragile our democracy is. And yet here we sit today, some of us acting as if what happened on January 6, 2021 never happened. After all the chaos and the damage and the injuries and the tragedy. We came so close to losing our democracy that day. Article 1, Section 5 was written just for this moment. And by holding this hearing, we are taking a step away from the chaos and towards accountability, a step towards restoring and further protecting the integrity of Congress. Because we've seen just how fragile our democracy is, and I look forward to exploring the constitutional framework of Congress's ability to discipline its members. And that brings me to my question, Mr. Wallner. I understand from your testimony that it's not appropriate for Congress to exercise its authority to discipline a member of Congress for following the rules which allow that member to object to the certification of a state's electoral college votes. If we did that, it would be wrong, would it not?
I believe that punishing members for following the rules and using the rules is not a good idea for
Well, let me
making the
ask you
House work.
this. Well, let me ask you this question. Do you believe that Congress has the authority to discipline a member should it be shown that that member, along with one or more other persons in any state or territory or in any place subject to the jurisdiction of the United States, conspired to overthrow, put down, or destroy by force the government of the United States, or to levy war against the United States, or to oppose by force the authority thereof, or by force prevent, hinder, or delay the execution of any law of the United States of to take, seize, or possess any property of the United States contrary to the authority thereof. If it were shown that a member of Congress were guilty of that conduct that I just described, would it not be within the wise use of authority for Congress to discipline a member and expel that member for such conduct?
Congress can expel a member for any reason it so chooses.
Well, no, I'm asking for the conduct that I just described. Do you think it would be wise and appropriate for Congress to expel a member shown to have engaged in what I did was pretty much read to you the law on seditious conspiracy, which is a crime under 18 USC section 2384.
And there are plenty of precedents of the House using its power to expel members who are engaged in rebellious activity.
Just requires a yes or no answer. Would it be wise and appropriate for Congress to expel a member who was found to have violated the provisions of section 2384 of the United States Code, the criminal code?
If the people who found that are a factious majority in the House and they believe that offering a motion or otherwise following the rules constitutes that, then I think that would be unwise. If on the other hand,
no, that's different than following the rules, sir. And you know exactly that it is. Following the rules is different than violating a criminal statute. If a person violates a criminal statute, namely engaging in a seditious conspiracy, and he or she is a member of Congress, are you telling me and you expect us to believe that you would not see Congress having the authority to expel such a member?
my point relates to the rules, and I'm not sure how following the rules would constitute that.
The rules. I'm asking you about criminal misconduct committed by a member of Congress. You can't bring yourself to say
we're running out of time.
You should expel that member.
If a member breaks the rules, violates the rules, or otherwise engages in treason, then certainly. If the member follows the rules, then I'm not sure how that equates with treason, and I'm not sure how one can punish that member without damaging the fabric of the House of Representatives.
Mr. Wallner, I appreciate your responses.
What happened on January 6, 2021 never happened.
Mr. Johnson, our time is up for this question. I appreciate you, and I don't want to get in anyway. Time's up, and I appreciate your questions, and I appreciate where you're coming from.
Thank you.
You're welcome, sir. Ms. Fishback, are you with us?
Yes, I am here. Can you hear me?
I can hear you, I can see you, and I'm not a cat. You're recognized for 5 minutes.
And did you get that joke?
Yeah, I did.
Thank you, Mr. Chair. You know, I am very proud to be a new member of Congress, and I'm proud and humbled to represent my constituents and of my district. But I really am troubled by the majority's continued partisan attacks. And, you know, my colleague, Mr. Johnson from Louisiana mentioned the increasing toxicity that's going on. And my colleague from Ohio, you know, pointed out that many of the Democrats that are still here have in the past voted on electoral college objections. But now that vote is being used for partisan attacks. And it's the kind of partisan attacks that will do nothing for unity. It does nothing to move our country forward. And it does absolutely nothing, you know, to help the citizens that we represent. And so I'm very, very troubled by what's going on with being, you know, with the partisan attacks on a vote that we took. Well, and Mr. Chair, I don't have any questions. I just wanted to make sure that I made that statement, and I will yield back my time.
Thank you, Ms. Fishback, and you're appreciated for your time, and you're glad to have you as a member. Next, I believe, is Ms. Garcia may not be with us. So if Ms. Garcia is not with us, which I don't think she is, the gentlelady from St. Louis, Ms. Bush, is recognized for 5 minutes.
Right. Thank you so much. St. Louis, and I thank you, Chairman, for convening this hearing. We appreciate you. You know, I came to Congress committed to one goal, to do the absolute most for everyone in St. Louis, starting with those who have the least. I intend to legislate in defense of Black lives and create a legislative path for liberating everyday people who are the backbone of this country. And it dawned on me very early on that not all members are united in doing the people's work within the people's house. That in fact, many are here to distract, detract, and disrupt our ability to do the work our communities elected us to do. This is a job. This chamber is our workplace. And when we ran for our respective seats, we knew that this job, what it would require. We knew that we would be heading to DC to deliver, not to wander the halls and do whatever it is that we wanted to. And like other jobs, we are expected to follow the rules. We are expected to engage in passionate debate. We are expected to legislate. That is our mandate, and that is also our job. In all of the jobs I've held, and trust me, I've held more than a few, we are expected to treat one another with dignity and respect. We're expected to protect one another and not risk the lives of our colleagues by ignoring life-saving rules to wear masks during a deadly pandemic, or by disregarding the metal detectors that are in place to secure the safety of our building and our bodies. These are the rules of the House. It seems to me that some members of Congress perhaps may have never held a job before. If they had, they will certainly understand that disregarding rules of conduct will result in consequences, that their behaviors are a reflection of the people they represent. In fact, when we hire our own staff, we make clear that what they say publicly, how they conduct themselves inside and outside of chambers and our offices reflects on our individual offices. Mr. Maskell, based on past precedent, is there any advice you can give us to help us evaluate when rhetoric crosses the line from strident to damaging the House's credibility and/or puts our lives in danger? And that I speak from personally, when the words that have come from certain Congress members have actually had death threats come into my office. So can you please share that with us?
Well, I'll give it a try, ma'am. Certainly passionate debate that you mentioned should be protected and encouraged. People should have the passion to express their convictions. However, to lower the temperature of disagreement the House has historically required civil discourse and has censured overly inflammatory and personally insulting rhetoric on the floor. And I think that kind of draws a line as far as the rhetoric on the floor goes. And that's what's happened in the past. So the House should not look to punish speech and punish passionate speech or punish someone for their ideas, but it should try to encourage civil discourse. Absolutely.
Thank you, Professor. Mr. Chaffetz, why is it important to understand that the House's disciplinary power is broad and encompasses more than the power to punish?
Well, it's important because, something I sort of said in response to an earlier question, it really is a necessary concomitant of the House's power to structure its own proceedings, right? For the House to be able to do its business, it has to be able to get out of the way those who would stop it from doing its business, right? So it has to be able to maintain order in the chamber, but I think even more broadly than that, it has to be able to maintain the constitutional order that actually makes it the House of Representatives in the first place, as opposed to just a meeting of a bunch of people. And it has to be able to maintain its own place within that constitutional order. So it has the authority to use its disciplinary power to remove things that threaten both the constitutional order itself and its place within the constitutional order. And it's absolutely essential that it have that power.
Thank you. To be clear, this is not about punishment. This is about integrity. This is about protecting the dignity of the House in which we all work so we can advocate and legislate on behalf of the communities that sent us here. This is about credibility. This institution derives its legitimacy from our conduct. It's us, from our ability to engage respectfully and to center the demands of the American people. And if we will not do that, then this is not the place for those folks. Thank you, and I yield back.
Thank you, Ms. Bush. I appreciate your being on the committee. Mr. Owens of Utah is recognized for 5 minutes. Is Mr. Owens not with us? If he's not, is Mr. McClintock here? If not, Ms. Jackson Lee is here, and I recognize her for 5 minutes. She needs to unmute and start the camera. Am I wrong? Is Ms. Jackson Lee not with us? Not here. I think she's not here. If she's not here, I think we've concluded the hearing. Let me get an idea here of who's still here.
You got Johnson.
And you got Raskin. Mr. Chairman, could I say something to Mr. Johnson?
Before you do, Mr. Raskin, I want to say this. I did make an inquiry. It is no longer, when you're the president, just like when you're a jet, you're a president all the way. But when you leave office on January 20, you no longer are excluded from having anything said about you in committee or on the floor. While we couldn't say the truth about the president when he was president, now the truth can roll down like waters from Jericho or whatever it is. With that, Mr. Raskin, you're recognized. Mr. Raskin, I can't hear you.
I wanted to thank Mr. Johnson, who I've always had a ton of respect for the tenor and the substance of his comments today. And if that was all we were getting, I would not have taken my time to defend us against the attack about cancel culture and somehow that we're hypocrites for having participated in nonviolent parliamentary process before. I was not responding to him. I tried to salute him for what he said, because I do think we need to drain the toxicity out of the conversation. And I hope that all of us can encourage all of the members to be working together. Obviously, we're going to disagree about stuff. This week, we disagreed about the $1.9 trillion COVID rescue package. We disagreed about the universal criminal background check. Fine, let's have the passionate debate about that. But the constant denunciation of other people as being illegitimate or attributing false positions to them. I mean, I can't count the number of times they're saying that we want to defund the police when there's not a member of Congress who's ever advanced a defund the police proposal or embraced one. And so that just gets us mad. So then we got to turn around and we got to talk about the fact that our colleagues are lying about us. And so that does elevate the toxic quotient in our politics. So if we can stick to the issues and as much as possible get to, revive those basic chords of affection that Lincoln talked about. There are a lot of the Republicans like Mr. Johnson who are just wonderful people. And I think that we, despite all of our differences, we can work together as Americans to move the ball forward. Thank you, Mr. Chairman, for allowing me to say it.
You're welcome, sir. Mr. Johnson, do you want to respond or do you yield?
I'll salute my friend and yield, and I agree with that sentiment. I wish all sides could put the weapons down. And the honest truth is, gentlemen, we're in a new era in our politics, and I know our witnesses acknowledge that because we have 24-hour news cycles and social media and all these other factors. So it's incumbent upon us to live up to the dignity of our offices, and I hope we can. So thank you. I yield back.
Thank you, Mr. Johnson. And did somebody else seek recognition or say something?
Mr. Chair, it's Michelle Fischbach.
Yes, ma'am.
I really, truly, I don't want to mess up the hearing, but I just want to say how much I appreciated your West Side Story reference.
Thank you, ma'am. Thank you very much. This concludes today's hearing. I do want to make this point clear. This hearing was for the purpose of getting the rules set, and I think our witnesses did a great job. And there was good substance offered, and the witnesses did a great job. So I want to thank all of our witnesses for appearing today. They all held themselves as they should have. And if I in any way didn't hold myself in responding to some things that were said that weren't true about me, I apologize. I shouldn't have done that as chairman. I need to hold myself above such things. But you get tired at some point of having continued things said which are false. With that, I thank the witnesses. Without objection, all members will have 5 legislative days to submit additional questions for the witnesses or additional materials for the record. And with that, I take out my Louisville Slugger souvenir bat and declare the meeting adjourned.